Hi guys. So thanks to Factual Lie, we have a link to watch, well, and the local Fox Syndicate too. We have a link to watch the sentencing for Damekion Garlington. If you missed yesterday, it was announced that he was taking an Alford non-negotiated plea. We're going to see how things play out. I like to front load with a summary when we have it. Typically, if we were able to watch this live when it was streaming live, there'd be the suspense, right? So what I want to do right here, if you want the suspense, mute for 60 seconds because we're going to do a summary right now. So mute me for 60 seconds if you don't want to hear the outcome. So here we go. 1, 2, and 3. So Damekion Garlington, state has recommended 20 years to serve with 25 on probation. We're going to see some updates. Lawyer asked for 45 years to serve 5, commuted to time served, and 5 years suspended, which would be time served and 30 years on probation. Conditions including, he's got to remove himself from any situations. He has to work for his mother's business. His mom's sister is currently speaking to the judge to share her plans for what Garlington's accommodations and employment look like. Hilton jumps in and says, hey, look, all this wiretap evidence, Garlington never learned his lesson. So we want the judge to consider that in sentencing. And then Whitaker comes back with the sentence. It's going to be 5 years with credit for time served, plus 20 years probation, and 5 years that will be suspended if probation is completed successfully, which maths out to about 2 more years of custody and then this probation series. So also banned from Fulton County. So let's get back over here. I think that was about 60 seconds. So we got it going. Let's see how this hearing actually played out. We get to see some familiar faces, but this time they are in Paige Whitaker's normal courtroom, courtroom 5D. So here we go. We've got closed captions. And hey to SteffJK, SSG Nunu, Ryder, Candace, and Crushing Hard on Max Shart here early to see how this goes. We'll jump a little right to where we see everyone come in.
All right, we're on the record in case number 23 SC 183572. This is a sentencing hearing for Mr. Garlington, who entered a guilty plea to certain of the counts against him yesterday. Okay, and we're on hold. They need a Zoom link. We can just use the one we're on right now.
Who am I sending it to?
Miss Warwick. And I guess this is. All right. So, we ready?
Hold on. I didn't make it jump like that, did I? Did I just mess that up, or is that the feed?
This is.
Okay.
All right. So, we ready? Okay. All right. So, is the state going to go first? And I don't know what the recommendations are at this point, so if y'all could let me know that as well.
Yes, Your Honor. Good morning, Your Honor. Today we're here regarding sentencing for Mr. Damekion Garlington. Yesterday, Mr. Garlington pled to count 1 of this indictment, which is conspiracy to commit the racketeering and things and corruption organizations act. Count 42, participation in criminal street gang activity. Count 49, which is aggravated assault. Well, murder, reduced to aggravated assault. Count.
Right. Sorry to be a Posy McPoserton, but let's stop there, especially if you missed everything about the plea yesterday as the news came out. So Hilton just had to stop herself and say, well, murder, well, the aggravated assault. So yesterday, when this plea was announced, Hilton told Whitaker, look, Judge, we are reducing the murder and the attempted murder charge that he's facing down to ag assault charges. Apparently Whitaker was very surprised by that. So that's what that little correction by Hilton was there.
Participation in street gang activity and counted before possession of a firearm during the commission of felony. Those charges are total exposure of 85 years.
Right.
As you heard yesterday, Mr. Garlington is currently on probation and indicted 15 SC 138894 for crimes associated with the April 28, 2015 drive-by shootings of Bell Avenue and Drew Drive. He received a total sentence of 15 years and served 5 years in confinement. That probation ends on December 27, 2029. The state brings that up, Your Honor, because as a general condition of probation, Mr. Garlington was not to violate any criminal laws. And as a special condition of that probation, he was to have no direct or indirect contact with any YSL members, no contact with any gang members, and no gang-related social media.
All right, and is the state seeking to revoke that probation?
Not at this time, Your Honor. And while we're not here for a probation revocation matter, the state thought it was important for this sentencing court to be aware of what Mr. Garlington was required to do, because he has failed to comply with any of those conditions.
That's interesting wording. Do you think that Hilton is well aware of some of the issues with recent motions for vacating sentences, relating to probation revocation, for somebody else that took a plea deal in the same YSL indictment? Listen to how she words that and tell me what you think. I haven't watched this yet. And while we're not here, we need to make sure we spell out the special conditions that seem to have been missing from Munktunk's probation.
And while we're not here for a probation revocation matter, the state thought it was important for this sentencing court to be aware of what Mr. Garlington was required to do, because he has failed to comply with any of those conditions. Instead, Mr. Garlington chose to continue to associate with YSL gang members, to include Shannon Stillwell, Kenneth Copeland, Jeffrey Williams, Khalid Adams, Jaden Myrick, Quantavia Greer, and that's the name of few. He then engaged in a conspiracy to attack a rival gang member, Rashawn Bennett, who was stabbed in the Fulton County Jail. That incident ultimately led to a retaliatory shooting that killed Christian McMiller and Darius Ford, and that murder led to another retaliatory shooting in which the state believes that Mr. Garlington was a part of, which was a retaliatory shooting that killed Mr. Shamel Drakes on March 14, 2022. After Mr. Drakes was murdered, it was Mr. Garlington on his social media post that said, "We got you boys." And this was only hours after the murder. And the state believes that was to indicate that he, along with Shannon Stillwell, avenged their friend's death. And even after that murder, it was Mr. Garlington talking with other gang members over the phone while certain individuals were in custody to get protection for fellow YSL gang member Miles Farley. It is the state deciding its recommendation, Your Honor. The state has taken into consideration a number of different factors. Mr. Garlington's previous criminal history, Mr. Garlington's involvement with the YSL gang from 2015, his continued gang involvement even while on probation, and Your Honor, we have certainly taken into consideration the results of the previous trial that we had before, Your Honor. Given that, Your Honor, it is the state's recommendation that for count 1, RICO, 20 years to serve in confinement. Count 42, participation in criminal street gang activity, which would be 20 years to serve, concurrent with count 1. Count 49, aggravated assault, 20 years to serve, consecutive, 20 years to serve concurrent with count 42 and count 41. Count 50, participation in criminal street gang activity, 20 years to serve consecutive to count 1, but on probation. Count 54, possession of a firearm during the commission of a felony, 5 years to serve consecutive to count 50, for a total sentence of 45 years to serve with 20 years in custody. As a special condition of that probation, Your Honor, He's had no contact with victims or co-defendants, no criminal street gang activity.
All right. So there's one. We actually have a condition not to make contact with the same people you're supposed to be a big, dangerous, scary threat to. When conditions like that, if they weren't wholly absent, right? We heard Doug mention that, or Doug ask several different witnesses that testified during the YSL trial that took plea deals to get out. Is one of the terms of your conditions, do you have to avoid people? Were you ordered to stay away from people? No. Finally getting some of the T's crossed and the I's dotted, maybe?
Association with criminal street gang members, no firearms or gun replicas, no gang paraphernalia.
Hang on.
If he has not obtained his CDP, be in school or gainfully employed, and any Fourth Amendment waiver, including social media. The state did have, just as some evidence in sentencing, Your Honor, these are items that were presented during the first trial, but some of the social media posts that led up to the murder of Mr. Drinks, Your Honor. And I'm showing it to the counselor.
She didn't look like she wants to see the pictures. Oh, did Abate get new glasses?
And Your Honor, first 36 exhibit 1, 2, and 3 are pictures of Mr. Garlington with YSL Associates Christian McMilner prior to his death, Your Honor. The third one is Mr. Garlington sitting with his back, his head towards the camera.
Is that a
with previous co-defendant Antonio Sumlin. State exhibit number 4 is a post by Mr. Shannon Stillwell, which was a few days before Chanel Drink's murder, which says ain't gonna be the only one crying. And then state exhibit 5 is the exhibit that I referenced earlier, which was done only hours after the murder of Chanel Drinks, in which Mr. Garlington posted, "We got y'all boys." Yeah.
You may. Any objection to those?
No objection. And Your Honor, we do not have any victim impact statements for this sentencing hearing, and so with that, we conclude the statement.
All right.
Mute some of this background noise a little until they start doing something again. Let's see. Hilton standing back up.
I did 45 years, served 20 years in confinement with a balance on probation.
Right. Yeah, that's what I understood it to be. Thank you.
Thank you.
Good afternoon.
So we were grateful for the negotiations that we were able to get to, at least partially. We couldn't get there on the numbers, but at least we got there on the charges. The state's indicated what they took into consideration in making us, I guess, kind of balancing what we were requesting. But I do want to just run through a little bit of Mr. Garlington's situation and juxtapose it to the other defendants. And at some point, like, better understand outside of the indictment, the charges and the posts. As it pertains to the charges here and in the indictment, I don't believe that any point anyone is alleging that he was a leader. And at some point in that 2015 incident, which is why he was on probation, he did cooperate with law enforcement. He gave a statement. They were questioning him about 2 shootings. He thought that they were only asking him about 1. And he did admit to his involvement in that one. His original sentence, I believe, was pending 2. And then ultimately he was resentenced to 15 certified credit for time served. served. I do want to point out that that probation violation was his revocation. It wasn't for him committing a new offense. It was for him being associated with a gang member. I don't have the case off the top of my head, but the 2024 case, and this was concerning the overly broad terms pertaining to child molester sentencing, said that it's overly broad to put that sentence do not have any contact indirectly or directly with children, right? I don't know.
Yeah, I think it was more that the condition that said stay away from anywhere that a child might be was overbroad, but I know the case you're talking about.
Yeah, and so, same situation here. I believe that might be, but I want to highlight the most out of there, that he was not engaged in committing a criminal offense. He wasn't subsequently charged for anything, and that revocation took place in 2020. We don't have him down for any other incidents until 2022, and that's where I would like to direct the court to his 2022 situation. Of course, there is an overview of the charges. Of course, we're aware of the RICO and what the overacts are. Most of the overacts concern pictures, posts, and conversations amongst friends. Then we turn to a jail incident. During the time of the jail incident, in custody, there was conversation between Mr. Arnold and Mr. Adams. We went through most of this yesterday. I saw on the Zoom.
Right.
But he didn't, what wasn't necessarily within the text message was there wasn't confirmation from him saying, oh gosh, did you guys get this done? Or wow. There was no request from him to make it public. Throughout the course of this, we've heard that the gang members seek recognition and acknowledgement, and most of the time they post their wins and whatever has happened. There's no evidence of that, and it's seeking to say, hey, post this, let them know that this happened, let them know that I was involved here. It's not bragging about it. There's no evidence of him taking credit for it. And there's no evidence that he paid for it. I think that the state's theory was that he was involved in some sort of payment for this incident to take place. And the evidence just doesn't support that. In fact, from the incident reports from the jail incident, it seemed like they had gotten into an argument, Mr. Myrick and Mr. Bennett, before this happened. Mr. Myrick had been wandering around for a while. They touched just a snippet of that. He'd been outside of, they were both in protected custody. He'd been outside of himself. And then at some point, Mr. Bennett was let out. Mr. Bennett had time to do his jail or his video visit in peace, and then some sort of argument ensued, and that's when they got into it. As it pertains to what happened with the Driggs case, I'm not sure if the court heard, but I just want to reiterate just this part.
I remember it.
Okay, no need to play it, Your Honor. But as it concerns Mr. Garlington, still we have no direct evidence of him being at the location. We don't have evidence of him being in the car, some DNA.
So right now they're talking about the Chamel drinks. We just went from talking about a jail incident to now the Chamel drinks incident.
That's a big deal.
That's what Whitaker was saying. I remember the video.
And there was very little evidence found in the vehicle to begin with for anyone. There was no evidence that they had planned to do this. And the post that was made after, and I get what the state would like for Mr. Garlington's intent to be behind that post, but it had nothing to do with Mr. Lynch. I don't think We Got Child Boys is just like a general statement of support. They were going to the studio that day. I'm not sure what inside jokes they might have shared. But I just am hesitant without there being other evidence to infer nefarious intent to a post that's so general in that nature. Of course, the video that the court is aware of, it doesn't even support, even if there was a reach to put him in the car, it doesn't support. Now, there is enough circumstantial evidence in place in there. There is enough from their FBI situation with the cell phone, but even with that, there's conflicting evidence as to the cell phone tower. At some point, early March, there was a wiretap placed on Mr. Garlington's phone. The FBI compiled this location data based upon his cell phone records. However, the wiretap is getting real-time locations of incidents. So this is what the FBI's looks like, and it's tracking. And the shooting takes place around 10 p.m. So they've got his time located from 9:46 until about 9:59 p.m. What's interesting with the cell phone, the wiretap data, is that it shows that he's traveling up I-85, and where his cell phone picks up, it bounces from one tower to the next. Where it ends up is north and that's this direction. I think it's north and east. North of 20, east of 85. And so the incident location takes place west of 85 and south of 20. So then 948, it's only pinging up in that direction, which is more indicative of that he was traveling up 85 north separately, whatever, and then came down. And that is consistent with him being found on the highway, not necessarily in that location. That real-time data at no point puts in where the location of the incident was or the gas station. But again, circumstantial evidence can go either way. And so Mr. Garlington was willing to take the risk on that in case of Alfred plea, Your Honor. But I would like the court to consider the sentences of other individuals in this case based upon their leadership role, Mr. Garlington's lack of leadership role, his cooperation with the lack of cooperation with enforcement. No evidence that he directly harmed anybody in this moment. For a lot of the previous defendants, there was no direct, or maybe there was enough guilty enough there was a presentation of evidence of direct harm, and his prior felony conviction. So what we would ask the court for is a global 40-10 and credit for time served with the balance suspended, and how we envision that would be 25 on count 1, credit for time served, balance suspended, count 42, 10 years probation, consecutive, count 1, count 49, 20 years of probation, concurrent with count 1.
How many?
20. Count 50, 10 years, probation consecutive to count 42, and count 54, 5 years to serve, balance suspended. Credit for count served, balance suspended.
54.
Yes, sir.
It looks to me like that adds up to, let me read that back to you. What the recommendation is, y'all are recommending 20, serve 5, balance suspended on count 1, 10 probation consecutive to count 1 on 42. 20 probation concurrent with count 1 on 49, 10 probation consecutive to 42. Is that what you said, or to 49 on count 50?
It was consecutive to 42.
Okay, that's what I thought you said. And then on 54, 5 to serve consecutive to 40 to 50 and suspended.
That was not, I think that was supposed to be the 5.
I don't know. What is it? What are you
He is holding a
suggesting?
couple.
Trying to understand what your recommendation
I got
is.
myself hooked on that there. I think the 5 was to serve concurrent, and then we got.
54 has to be consecutive, right?
I'm sorry, it doesn't have to be consecutive. But it's 45.
So that would really be 45, right?
Yeah. Yes.
To serve. And you said 45 serve 10, but I don't see where that's coming from.
I'm sorry, it's 45 certified because I didn't get balance suspended on that, the weapons charge.
All right. Anything else you want to present?
Yeah, sure. I'm going to look at his family members getting opportunities to speak. What his, what we envisioned was not to just come in here and blindly ask the court to give him probation without a plan. I don't know what the court's take is on this, but a lot of this seems to be the situation where we have back and forth. Something happens to someone, and then we have something happening to someone else. We're trying to minimize his involvement going forward and his need to engage in other criminal activity.
Well, there's never a need to engage in
Yes,
criminal
correct.
acts. I want to rephrase that.
I understand.
It said no.
What, or the perception, right? So what I've seen here is, without throwing anybody else under the bus, other individuals still carrying weapons under a presumed, that I'm presuming that would be the reason why, is that you feel that you are somewhat at risk, despite that being against the terms of your probation and against
The
what you're
law.
lawfully allowed to do. I don't even want the feeling of that, and I think the best way to alleviate that risk feeling is
Amanda
to
Fulton.
remove Mr. Garland from these situations and to have a plan going forward
Okay.
about what he's going to do with his life. He and I have spoken extensively about it.
I mean, I think it's something that every attorney should address during a sentencing hearing like this, because, you know, we're going to have a plan for employment, who this person's going to stay with, why they're going to stay on the right track and be a productive member of society and not end up right back in front of you. But I like the way that she also kind of made a little bit of a I guess you could tie it in specifically to issues within the YSL indictment. But I think it's just a broader statement that if you come from a background where people might be putting a target on your back, appropriately or not, either they want the revenge because you did something bad in your past, or they want the revenge because you were publicly accused and charged of doing something that you didn't do, and somebody just might want to get their retribution. When you have a status attached to your name, you can't just go out and carry a firearm anymore to protect yourself. You lose the right that most citizens still have. So she's making a bit of a social statement here while also presenting a plan. Like, Judge, please listen to our recommendation, give our recommendation greater weight than all of that time that the state wants you to go with. Lean more towards our recommendation. We're taking these extra steps. We've put a plan in place. And we understand that we need to get him out of this area to keep him away from everything entirely, because he's no longer going to have a right to protect himself. And we don't want to put him in a situation where he's going to do something illegal, like possess a firearm, because it's a catch-22 for him. And I think that's a huge predicament. Think about how often there's revocation or someone gets picked up on a new charge because they're possessing a firearm while they have felon status. So she's kind of making a little bit, I feel like she's poking at the way this district attorney's office and many others and police departments will just look for that gun. We'll look for that gun and you'll end up right back here. And you put these individuals in a choice to decide, let there be a target on my back with nothing to do about it, or get another charge. And she's saying we made a plan, an option 3. I think that's really, really important.
Of course, one cannot make plans from inside the jail to an extent. A lot of his plans involve leaving the state entirely, which I support. That would alleviate a lot of the risk.
Okay.
It's not just a risk for him, but as we've seen in the facts here, it becomes family members, other people, friends that become unintended targets of these various acts. On short notice, we weren't able to lock in a lot of provisions for what he could do and what we hope he's going to do. But I do want his family to at least discuss with you about the plans that they have, so that the court understands that we're not just saying, hey, just let him go. We'll hope for the best. No, we have something.
Okay, have you discussed with the family what those plans are?
I have.
Okay, well, why don't you let me know what they are?
So generally speaking, his aunt is a business owner. She owns a number of businesses. And so she's able to employ him. One is like a lawn care service. She's got several contracts for that.
Is this local?
Not local in Atlanta. I think it's Metro Atlanta. Is that correct?
DeKalb County.
DeKalb.
Pretty local. Okay. What other ideas?
So that would just be the first one.
Yep.
I would like for her to speak about who she reached out to out of state. So she's got other relatives out of state that she was able to speak to. I wasn't able to speak with them directly, so that's why she went to the court to allow her to communicate directly about what those plans are.
Okay.
Would you like me to go to video on it?
Not to just tell me what her idea is for his
I think this is
rehabilitation.
Mom.
Hmm?
Good afternoon.
Good afternoon.
My name is Marquita Cook Johnson. I am Damekion's maternal aunt. I am a native of Atlanta. I'm a military veteran. I do own 2 businesses here in DeKalb County. One is a salon wellness retreat, and the other is a boxing gym, which my partner and I own together. This was a very short notice. I do understand as far as my goal is to get him out of Atlanta as a whole. Prior to his arrest, I had taken him on his first out-of-town trip to get him acclimated to traveling and just seeing what is outside of Atlanta. I was stationed on the West Coast in California. I have several connections there, and as well as Virginia, mostly states where military people reside. I have reached out to a few of my fellow shipmates who are now retired, like I am, that are in a position of mentorship. I feel like for Damekion's safety and as well as my family's safety, it is best for them to relocate as a whole. And also to have realistic expectations. I have in the past had custody of Damekion. He knows I run a very strict household, but even as an adult, at this point, he needs to have a curfew because outside is not the greatest place right now. So, under the terms of him being able to come for immediate employment. My partner is also law enforcement as well in Rockdale County. So in order for him to come and, gain employment with us, he will have very strict accommodations. And like I said, the long term is to get him relocated out of this.
All right, thank you. How much time has Mr. Garlington already served on this case?
Your Honor, Mr. Garlington has been in since September 28, 2022, which is 974 days.
All right, anything else from the defense?
She just make that face. She looked like she saw something crazy on the computer.
The custodian will be able to correct, but I think it might have been May when he got arrested.
I checked Odyssey and that was the date.
Ms. Shelley, can you let me know what you show for his time served so far?
As far as the jail
Pre-trial?
law, say what now?
Pre-trial? Yeah, well, yeah, in jail.
I don't have access to the
don't?
pre-trial system, just regular
Oh,
felony.
okay.
Things.
Oh, darn. What do you show? I mean, there's an arrest date of May 11th, 2022. Whether he was released and rearrested, I don't know.
He went to prison, so he said.
Oh, okay. Yeah, well, that part I don't think would count in his favor. I don't really know how they. But it wasn't on this case. If he went to prison, it would have been for some other case.
Custody
Well, they probably didn't mean prison. Let's see.
of this case, even though he was in prison on the case. I'm not saying his prison time.
I
I'm
don't-
talking about when he was first arrested was May 11, 2022.
Okay,
on
well-
these charges.
It's either 974 days or 974 days plus about 4 more months, right? All right. All right. Anything else from the defense?
Nothing from the defense.
All right. Any rebuttal, I guess, from the state, which I don't know if that's the thing, but anything else from the state?
No, Your Honor, I believe that you've heard a number of the
Wiretap evidence, within the first trial, Your Honor, that we don't need to reiterate. It is the state's position that Mr. Garlington
She just said, no, we have nothing to add, and now she's adding. Like, come
was
on.
given an opportunity to redeem himself when he was resentenced in 2020. And as opposed to working with his aunt or as opposed to leaving the state then, that's not what he did. He re-engaged in gang activity in which we have the text messages regarding the stabbing of Mr. Bennett. And while there might not have been payment, Mr. Adams, after the stabbing of Mr. Bennett, surely reached out to Mr. Garlington on multiple occasions to try to get payment for that particular incident, and either never transpired, but there was some expectation of payment for that act to be completed. Again, after the murder of Mr. Drain.
The state's theories are crazy. So Khalif Adams says something that seemingly looks like he's expecting payment from somebody else that he's in jail with. Is there no scenario where somebody does something and goes to another inmate and says something to the effect of, you better pay up for that? Is the only explanation that it was a premeditated plan and there was a promise by Garlington to Adams that I'm going to compensate you financially if you specifically do this thing? Did you hear how she just presented that? And not for nothing, but pretty sure Khalif Adams was one of the ones that had everything null-prossed. All the charges dropped in December relating to this. He's still doing time for another case or other cases. I don't know the specifics, but they null-prossed these jail charges that are being discussed right now, the inmate fighting for Khalif Adams. So
there was laughing about the murder on the wiretap. There was a concern about cleaning the vehicle. And then that is all from Mr. Garlington's mouth and words. There was concern that other co-defendants were going to tell. And how do we get that person not to speak? So Mr. Garlington, unfortunately, never learned his lesson the first time around. If he had, maybe we wouldn't have been here, and that's
Okay, thank you. I'm going to take about a 10-minute recess, and then I'll be back with the sentence.
all right, so we can skip the recess. I think they're just gonna, well, unless they do anything fun with the court. We'll mute it. I don't think they're gonna say anything. But if you guys want to look around the 5D courtroom. But yeah, no, Your Honor, let me keep going. David says if Love was there, she would drag this into next week. We should be grateful. Why are they zooming in on Atkins' ear hair? Oh no. Oh, this camera person, guys. Where was it? Factual Lie had said in McBurney's courtroom, because McBurney streams all of his courtroom stuff live. Chitter chatter? I think they're just chitter chattering. But Factual Lie said yesterday, with whatever was going on in Judge McBurney's court, Judge McBurney said something to the effect that there's a shift around with the ADAs. And I'm not exactly sure what this means. Factual Lie said they're going to go re-listen. But I do know that there's been shifts in promotions. There's also been exits. There's also been like department shifts. For example, I know Christian Atkins was promoted. And Love was not fired. I saw you guys asking earlier. Love was not fired. Love is still there. Dang, the camera guy could have zoomed in on the seal. The little electronic seal. Alright, so let's wait till we see Whitaker come back out. Probably like right about here.
Can we get Mr. Garlington back up? Can the state provide what the statute for aggravated assault is on that lesser on 49? Thanks. 49, yeah. You have this. Okay. Yes. And they've null processed 40, 43, and 43 and 51. All right, we're back on the record, and I have taken into consideration the state's recommendation, the defense recommendation, the evidence that's been presented. I also am obviously aware of the evidence that was presented in the other trial, and I have taken a look back at the sentences that this court imposed for co-defendants from the prior trial, including co-defendants who were charged with some of the counts that Mr. Garlington is currently charged with and has entered an Alford guilty plea to. Also taken into consideration his prior record as well as the prior records in the other cases in which this court sentenced. Also, other than one of the sentences imposed by this court in the first trial, the sentences that were imposed were joint recommendations, and I've taken that into consideration as well. The sentence for count 1, which is the RICO count, is going to be 20 years to serve 5, the balance of 15 probated. Count 42, the sentence is 20 years, serve 5, balance probated, concurrent. The sentence on count 1 reduced, I'm sorry, not 1, count 49 reduced to aggravated assault under OCGA 16-5-21. Is that what you said, 21? Okay. Is 20 years to serve 5 with the balance probated, concurrent with the other sentences. And I'll note in that regard that one of the defendants charged with that set of crimes was found not guilty, and 2 others, the state decided to null pros the counts against them. In count 50, the sentence is 20 years, serve 5, balance probated, concurrent. And then the sentence for count 54 is going to be 5 years consecutive to count 50. And it can be suspended upon successful completion of probation. So that's essentially 20 years, 5 to serve with credit for time served, 15 years probated, followed by 5 to serve, which can be suspended and will be suspended as long as the probation is successfully completed. Special conditions of the probation: no contact with any of the victims in this entire indictment or with any of their family members. No contact with any gang members from any gang whatsoever. No gang paraphernalia, no gang associations, no guns, no replicas of guns. You need to secure full-time employment within the first 6 months after you're released from probation. You need to sign a social media waiver and a Fourth Amendment waiver. And that is going to mean that during the entirety of your probation, law enforcement at any time they want to can look at your social media posts, can search your person, can search your home, can search your car with or without probable cause to ensure that you do not have any gang paraphernalia, any guns, any drugs, anything you are not supposed to have. You need to secure your GED, which I know you told me yesterday you were working on it and had gotten to parts of that already. Go ahead and get the rest of it within the first year of your probation. And I am going to require that you stay out of Fulton County for the entirety of your probation. All right, that is the sentence of the court. I hope that, as I have said with the other defendants whom I've sentenced, that this has been an opportunity for you to realize that the direction that your life was going is not a good direction, and that you are determined at this point to turn your life around and make good decisions from here on out. Associate yourself only with people that are going to help you to stay on the straight and narrow. So you've got a little bit of time left to serve before you're released. I think a couple of years at least, but go ahead and do that. You can be working on your GED and on job skills while you're in prison. Good luck to you. And I hope not to ever see you again, because if you violate your probation, you're coming before me. So let's make that not be a thing. Okay. All right. Good luck to you.
You want me to add that, Judge?
What?
In violation
Back to me. Yeah. All right. That concludes court for the day.
So I've never really heard that spelled out in that manner, where it's explicitly stated a social media waiver. And my interpretation of that, because we're also including the Fourth Amendment and, checking for any paraphernalia and everything, I think that could also mean private messages. If they want to see private messages, if they want to be able to tap in and look at that stuff, they don't need to establish probable cause. So that stuff's real. That stuff's real. And the way that she specified that here, I don't know if I think that that's that much related to Jeffrey Williams and the post about Viverito being the biggest liar in the DA's office. Rather that maybe Whitaker feels like Damekion Garlington is very lucky at how trial 1 played out and how the state has had a lot of weird reaches and mistakes and sloppiness throughout this entire prosecution. So I've just never really heard that spelled out like that, a social media waiver as part of, part of these terms is you could be searched. Cool. I've never heard it explicitly expanded to that. So that's new. And I'm surprised I didn't see that reported. So I think that's something worth talking about, you guys. I mean, there's like 300 of us in here. Not necessarily in relation to Damekion Garlington, but next time you see another case and another sentencing come down and it's talking about these limitations, just remember, like, we have we have a judge now explicitly stating this. And it might not be the first time, but super, super interesting. But yeah, you guys are like, damn, wow. Yeah, she's steep. Yeah, I would say steep. And yeah, Corky, I immediately thought of the Young Thug post. But her response there was so like, hey, it'd be good to not put yourself at risk. She gave a warning, but her warning was kind of within the context of this DA's office is going to be looking at you. It wasn't related to losing your rights to your speech, or losing your rights to not have somebody search without probable cause into your whatever you're doing in your life. So it reminded me of that, but this seems very, very different, although related. And yeah, so for Always Forever for Life, it's not unusual to have, I mean, I'm not saying it's common, but it's not like not allowed to make it a term of sentencing that, law enforcement's going to be able to have their eye on you. You're losing some of your freedoms because of this sentence that I'm imposing. So that's not allowable. It happens. But just having it laid out like that is real specific. So overall, what did he can't go, how did she word that? Can't go near any gang members, can't go near any victims in this indictment or their family members. And I mean, guys, I don't know how that actually pans out. I'm pretty sure if his best bet, again, just stay away physically, get in another county. Can't be in Fulton County. That's going to solve a lot of the problems. But what if he's like vacationing and runs into someone they know? I mean, you've got to just make the best of the situation and keep it separate. Don't message anybody. But yeah, so he's going to do, because of the timetables of what he's already served, he's got about 2 more years that he's going to be in custody. And remember, he's got this 20 years probation plus 5 years on top of that, but it's suspended. So he's got to make it through 20 years without issue to make sure it doesn't become 25 years, the 5 years suspended. So let's see. I don't really see articles with any new information. It just respells out his sentence and then mentions that there's 2 remaining. I said earlier at the beginning of the stream, when we were done, we would look at the docket and see. I think the guy is Thomas Mondelli, but I don't know the woman that was speaking. I don't know her name, so let's pull that up. And I don't know, at the end of the day, guys, my opinion is these they came in and said, we think our client should have a plan to be physically removed from this risk he'd be facing that would put him in the catch-22 of feeling like he needs to defend himself, even though he might and likely will lose that right to possess a firearm after you come back with your sentence. So, and then the judge, of course, stay away from it. Stay away. Let's see, we've got Damekion Garlington. And yes, all I know, guys, in the chat, all I know is that the woman who spoke on his behalf, saying that she had a plan for employment because she has 2 businesses, that is Garlington's aunt. I don't have any other assertions to make about that, but it was his aunt. Danielle Warlick, I'm seeing here. So there we go. That was probably Danielle Warlick. Also, huge shout out. Got new faces in the building here, joining in late. So if you're joining in late, thanks for hanging out. We're wrapping up here. Buck Rogers sentence. Hold on. I don't get the reference. So I have to Google it. Was it like a super long probation sentence? Oh, he had a life sentence. He had a life sentence there. So long sentence there. Buck Rogers. Based on a Google search. AK says, was he really on the wiretap talking about cleaning the car? I can't remember. Honestly, that's a blurry... I just remember them saying that it's going to come back clean. Or something like that. And remember they argued, I submit to you it's going to come back clean because they cleaned it. That's consciousness of guilt. Versus, it's going to come back clean because there's nothing in there to show up. Because nothing happened there. We know it's going to come back clean. Because why wouldn't it? Because we didn't do anything. Which was the defense's argument about that particular statement in that wiretap call. So I think that's what they were referring to. However, there could have been, maybe there's something that we didn't really hear argued during the motions hearings because it was different defendants in trial 1 and, you know, confrontation issues, Bruton issues could have kept certain things out. But I feel like during those hearings, we heard them try to get things in, right? So I think they meant just that, like, they're not going to find anything. It's going to come back clean. And state's interpretation of what that could mean versus the defendant's attorney interpretation of what that could mean. But that was a hot mess. And remember, guys, Juror 409 did an interview 2 times on Dennis Byron's channel, and she was fixated on that cleaned car. She said there was a picture that was shown where you could see water droplets, and that was, you know, a lot of people were saying from like the tint or when you run your windshield wipers, but when you get your car tinted and they like squeegee things down, there could be drips on the like plastic part of the frame right below where your window starts. But Juror 409 said that wiretap call and the little dried droplets in the photograph were solid proof beyond a reasonable doubt for her. She would have convicted. So make of that what you will. Everybody's different, right? Yeah, so that's my recollection of the call, you guys. It seems familiar to David. It seems familiar to AK. That it was just there. It was to the effect of they're not going to find anything, and then it's up to interpretation what is behind that language, right? So it wasn't just a flat out, we cleaned the car to remove all of the evidence of the crime we committed, so they're obviously not going to be able to find the evidence of the crime we committed. That's not what was stated on the wiretap. Also, it's been great to see you, BigBabyJane. I hope you are doing well. BigBabyJane says, hey, Kat, hey, chat, good to see you guys. Flesh of the Gods popping in. And I'm glad you did. You got in here right as I'm doing my Hilton impression here. If I submit to you about cleaning the car. Flesh of the Gods says, yo, peace fam. She said, give up your 4th Amendment. And it's not anything that I think courts take lightly. And sometimes I'm sure some judges do. And maybe they shouldn't take away that right so loosely. I don't really think that was what was happening here. But to see it extended with the specifications of the social media is just like, can you imagine how the DA and APD feel about that? And I didn't really hear Hilton request as a condition a waiver. Maybe I missed that earlier. I think that was just what Whitaker came up with. I didn't hear Hilton ask for that specifically. So But now that it's been asked for, now that it's been stated by a judge as part of sentencing, I feel like the state's going to start asking for that in future recommendations. So just a whole thing. And guys, I'm going to put this on the screen because we're getting questions here. Although this is missing the context on this social media waiver and the Fourth Amendment waiver. So with that included, 5 years with credit for time served, 20 years probation, 5 years that will be suspended if probation is completed successfully. So he's got about 2 more years of custody before being released, and he's banned from Fulton County while on probation. So for decades. It's basically like a life banishment. Let's see. David says, surprised the state didn't have someone watch the movie Car Wash to become a car cleaning expert. Not the Tyrone Dennis reference. We might wrap this up with a quick visit to a Tyrone Dennis appearance in another case where there was just a reversal. The Darren Mills case. We're going to take a look. That'll be what we end on. Also, David Traylor, thanks for becoming green. Big thank you here. Joining the gang. If I ever lose my Fourth Amendment rights and people have to look through my social media, they're going to see that you guys joined my gang. They're going to see it. And let's see. Holy moly. Well, I got a notification from Thugger Daily. It's not YSL, but maybe interesting news to you guys. NBA YoungBoy is now pardoned. He has a pardon. So, there we go. There we go. Busy day. Still no word on potential plea negotiations for the remaining 2 co-defendants. That's Christian Eppinger and Demise McMullen. Trial, like jury selection, that's set for the 9th. So, like a week and a half away from now, 2 weeks from now. So who knows? If that pops up, we'll talk about it. And let's get over to this little Tyrone Dennis appearance. I think you guys will enjoy it if you haven't seen it over on X. So you guys know the drill with Jim, with Happily Angry Lawyer. He likes to leave context out, but I provided it. It's okay. Yesterday, he mentioned, let me pull up the tweet and share it with you guys. So, yesterday, Law and Crime covered Darren Mills' reversal. So that was exciting to see a spotlight, national spotlight on, a smaller player in a case with issues in Fulton County. So Jim retweets and says, actually innocent. If anybody belongs in prison, it's Detective Tyrone Dennis. Oh, what were those GBI? GSW residue test results again. I can never remember. So this was the context. This is what he's talking about. He says, well, what about the forensic evidence, you might ask? Surely there weren't any bold-faced lies from the state on that point. This was the briefing regarding the request for a new trial. Crime scene investigators processed the gold Suburban and found gunshot residue on the windowsill. Here's the report. You see Tyrone Dennis. Let me make this bigger. Got Tyrone Dennis, subject Darren Mills, victim Hassan Pope. So remember yesterday, I don't think they need to use initials. The victim's name is known in the case. Evidence. We've got a sealed gunshot residue collection kit identified as containing samples from the rear window seals of a Chevy Suburban, and sealed gunshot residue collection kit identified as containing samples from the front window seals of a Chevy Suburban. So they checked all the window seals. Conclusions. Examinations of items, those same items, failed to reveal particles characteristic of gunshot primer residue, GSR. Results. Examination of items, the same items, failed to reveal particles characteristic of GSR. But let's just so we don't lose anything here, what did the state's brief say in response to the request for a new trial? Crime scene investigators processed the gold Suburban and found gunshot residue on the windowsill. Just the windowsill, too. They didn't specify which windowsill. Does any of this surprise you guys? Just like a hot mess. And yeah, factual lie with the never unnecessary reminder that don't let Viverito know. I mean, Viverito probably like got a text as soon as somebody walked out of that courtroom, like, you heard? You got the word? You want to go back over to APD? Because there's like and this isn't unusual either, but there's definitely a pretty tight pipeline between APD and the DA's office. Like the way that APD becomes detective and they're all gang experts that learn and conference with each other. Just one big happy family over there. Somebody probably already gave Viverito the memo. If she wasn't watching herself. She could have been watching that hearing herself to see. And I think... Okay, it showed me a new update from Thugger Daily, but it's just the NBA Youngboy news again. So I think we're caught up, you guys. I think we're caught up there. Any news on plea negotiations for the remaining two? We'll go live, we'll talk about it. It'd be interesting to see how plea negotiations might go. Maybe they were waiting for the sentencing to come down to make some decisions. The sentencing could impact the decisions and negotiations if they're still ongoing with the remaining two co-defendants. Honestly, if I was the state, and especially since this isn't Adrian Love pursuing this anymore, the remaining set at the state's table seems more willing to null pros and drop some things, reduce some charges, even though they're still trying to maintain in their factual basis. You know, the evidence clearly showed that they admitted to these crimes and did all of these crimes. It seems like they're trying to get rid of this trial perhaps entirely before it starts. So if I were the other two defendants, because Demise is facing the murder charge, Christian Eppinger is facing a bunch of charges. The tricky part with Christian Eppinger is he is charged with attempted murder against a police officer. Probably be a hot button issue if DA's office decides to offer a plea there. But there was a whole issue with his bond. They messed that up already back in April 2 years ago. So they've already been in hot water for not taking seriously the alleged attempted murder of a police officer. So who knows? Who knows? We'll cover news as it comes out. Here Comes Drama says, love a good gym rant or post. Heck yeah. Heck yeah. And Martha Griffin, yeah, you know, if you don't have X, I totally get why people don't have X, or honestly just try to stack on a bunch of social media apps. Like I keep saying I'm going to try to use TikTok. I never do. I have it downloaded and I know everybody's on there. But I will continue trying to share updates from X with you guys that are relevant to whatever we're talking about. Yeah, not on Instagram. That's like their favorite app to look at is Instagram, it seems like. So, but yeah, there we go. There we go, you guys. Let's wrap this up. We'll find a quick redirect. I think Karen Reed is over for the day. I would assume. I don't really think Bev Canoni really goes this late. Oh, and as far as the Moonchunk update, I do expect filings coming down. I don't know when though, but if you missed yesterday, I kind of characterized what Tiffany, the Fit Lawyer ATL, and Jim are doing as like Russian dolls. They've got all these different arguments, but you know, they've got to start with one, and if that doesn't go, then they've got to unpack and use the next vehicle, right? So there's going to continue to be advocacy for Antonio Sledge. We'll talk about those filings, of course, when they happen, but of course, make sure you guys are supporting the Fit Lawyer and Jim, the Happily Angry Lawyer, because they're taking that case for free. Taking that case for free. That's incredibly honorable. Let's see. Okay, as far as who is live right now, Lawyer You Know is live, and I think he typically starts later in the day, so that might be a newer stream. Nick is live. You guys want to go over to Nick? We can go over to Nick. Because I don't know if he started on time. Oh, it says scheduled. That's weird. Scheduled for 4:18, but it says live. Well, I don't know. It's showing the live play button, the live red button, but then it also says scheduled. So who knows? We'll see if we end up over with the Viking crew, you guys. See you over there or tomorrow. And everybody, please take care. Good to see everybody. Bye, guys.